Welcome to JCEE Connect. Yesterday's class we were discussing about the um, which are the uh, duties of the arbiter that we have discussed. We have discussed the types of the arbitration process, that is voluntary arbitration and the compulsory arbitration process, and what are the essentials of voluntary arbitration process that we have discussed. So we have struck with the compulsory arbitration process. Some of the essentials of compulsory arbitration processes are, um, first one, of course, this whatever the arbitration process, compulsory arbitration process has to pass through the economic crisis only, because most of the disputes are come under this compulsory arbitration process, or um, uh, economic disputes only, so that all the economic disputes has to pass through the overall economic um, crisis. Then some of the industries of strategic importance has to be taken care of, because most of the industries are having their own strategies to improve the economic um, status of the industries. Even that has to be passed, and that has to be involved during um, all these processes. Then the both the parties has to be ill balanced. The compulsory arbitration leaves no space for the strikes and lockouts. It deprives both the parties of their very important and fundamental rights. Of course, in some instances, the opinions can be taken from both the parties, but most of the time, uh, um, some of the scopes for both the parties to tell their opinions will not be involved in some circumstances where the cases are very sensitive. Only to send one uh, report to the parties by both the parties to the arbitrator, and there will not be any provision for their discussions. I will read it and we will finally announce the award. There will not be any scope for discussions under some scope, but these kind of things will not happen in the courts. In the courts, you have many provisions to discuss, to deprive, or you cannot discuss. That kind of provisions will be there in the court itself, but here some scope will not be there, it will be restricted. So then some other types of arbitration process are there, that is ad hoc arbitration, institutional arbitration, statutory arbitration, domestic or international arbitration, then foreign arbitration. Now what is this ad hoc arbitration? When a dispute or the differences arises between the parties in course of commercial transactions, if assuming that if any dispute is happening, then this arbitration process is agreed to get the justice for the balance of unsettled part of the dispute only. Means whatever the justice is there, it should be for only unsettled part of the dispute only. That kind of arbitration process we can call it as ad hoc arbitration process only. Second one is institutional arbitration. Here there is a prior agreement between the parties. Here one agreement they will make it. In case of future difference or the disputes arising between the parties, during their commercial transactions, such differences or disputes will be settled by arbitration as per the clause provided by the agreement. See, in this very important institutional arbitration is even the arbiter itself, he will do an agreement saying that no claim for the further uh, or no, there is no provision for continuation of the dispute once it is awarded. So if they will make an agreement, even the small differences happened for the first party or the second party, or if even a small percentage is go in the favor of the first party, then he cannot claim it. That kind of agreement they will made it, means if um, during the agreement what they will mention is that if anything is a small percentage go to either the first party or the second party, both should not claim that it is impartial. That kind of agreement they will make it. That process we can call it as institutional arbitration process. Then statutory arbitration. It is a mandatory arbitration which is imposed on the parties by operation of law. In case of such, the parties have no options as such but to abide by the law of land. So then, what these during this process, statutory or arbitration process, a statutory law is imposed or statutory court is intervening the process of arbitration. So in these cases, the law is enforced to make the arbitration process smoother and make it flexible. So means in this law, what they will tell is that these are process and these are benefits you will get it. Even if you are not satisfied with this, even you can continue with the law. That kind of arbitration process we can call it as statutory arbitration process. Then domestic or international arbitration. Arbitration which occurs in India and have all the parties within India is termed as a domestic arbitration. Whatever the things are happening in India and both the parties are within the India, that process we can call it as domestic arbitration. An arbitration in which any party belong to other than India and the dispute is to be settled in India is termed as international arbitration process. So this is very important aspects. Assuming that the two parties are other than in India, assume that they are NRIs, and their disputes is there that has to be settled in India itself. In that kind of cases, we can call it as international relations, but that has to be settled in India only. That dispute has to be settled from India only. Then the arbiter has from the own country only. So in that cases, we can call it as international arbitration. What is a foreign arbitration? Arbitration when the arbitration proceedings are conducted in the place of outside India and the award is required to be enforced in India, it is termed as a foreign arbitration. In this foreign arbitration process, whatever the arbitration is going to happen outside India, not in India, like your the previous case what we discussed. This has to be conducted in outside, but the judgment has to be made in, or it has to be enforced to make a judgment in India only. Whatever the award what we are speaking about in the process of arbitration process, that has to be done in India only. Final award has to be done in India only. So that is nothing but foreign arbitration process. So what kind of laws are there uh, to help this arbitration process? Normally, Indian Council of Arbitration Act is there. That is 1965. Of course, that has been improved. It has started 1965. Now they have revised many times. We have revised codes are available with some of the modifications in that council or in that arbitration law. And one more is there, Abide Arbitration and Conciliation Act 1996. That is, so for this all two acts legal framework is there, how the arbitration process has to proceed, and what kind of duties of arbitration is there, what are the sections are involved with relation to the arbitration and the law of land. And in this, even if you see, many are of type ad hoc type of arbitrations are there in this all laws. That is 95% arbitration is of ad hoc type of uh, process. Of course, India number one, number two in arbitration cases reaching the Singapore Center. Of course, it is number two in most of the arbitration process. Then Mumbai is some of the headquarters are available. Of course, Mumbai has to the India's first international arbitration center, and now it is there. Uh, the last year only, the center has inaugurated. It means that Mumbai is the headquarters, and those who want to make the arbitrator make it arbitration process, and he has to mention as an arbitrator, he has to take the centralized license from this Mumbai center only. An arbitrator may be initiated and the award made and compiled with or without the assistance of intervention of the court. So he can award with intervention of the court or without intervention of the court itself. Many of the things we already discussed regarding this, where to intervene and how to intervene, what cases are there. If you take a case study of the um, dispute related to the tendering process, even it can be solved without the intervention of the court or with the intervention of the court also, because of course it depends on the how agreement you will make it during the process of tendering. So that has to be carefully discussed. However, if it becomes necessary during the course of arbitration proceedings to seek the assistance of the court, any party could do so to appoint an arbitrator in some circumstances. Sometimes, once arbiter solved, even the parties can go to the court and they can claim that whatever the arbiter has done, it is wrong. So we need the orders from the court itself. Then whatever the arbiter has given the awards, that is going to cancel. And sometimes even many times what has happened is the arbiter will give some decisions, even both the parties will not satisfy, they will go to the court, and the court will say that the same things they will award even after 5 or 6 years. That has many examples are there. So without an intervention of the court or with intervention of the court, they can do it. So of course, what are the objectives of? They may ask, what are the objectives of arbitration, or what are the? This may be asking what are the duties of arbitration process also. So first one is to comprehensively cover international commercial arbitration and conciliation, as well as also domestic arbitration and conciliation. So it has to cover most of the international as well as the national conciliation processes. To make provision for an arbitral procedure which is fair, efficient, and capable of meeting the needs of the specific arbitration. So, of course, that we already discussed, that is the duties of the arbiter. Same, they may ask the objectives of arbitration process also. So, means the arbitration process should be fair and transparent. To provide that, arbitral tribunal gives reasons for the arbitral award. So, whatever the arbitral tribunal, what we can call it as that they have to means arbitral tribunal in the sense arbiter will not be there in the say in one arbitration process, one or two or three arbiter may be involved to solve some of the disputes. So in that case, the reasons will be provided. Why should we give award to this person? To ensure that arbitral tribunal remains within the limit of jurisdiction, it has to be made it under the uh, limit of jurisdiction to minimize the supervisory role of the court in the arbitral process. That has to be maintained. Next one, to permit an arbitral tribunal to use mediation, conciliation, or other procedures during the arbitral proceedings to encourage the settlements of disputes. Because many things we already discussed these things. Then to provide that every final arbitral award is enforced to the same manner as if it were to degree the court. So when the law of land or the law is enforced on the um, arbitration process, then care should be taken when you are doing the arbitral award. Sometimes during the arbitration process, the court may intervene and saying that you're not supposed to do this because assume that say 80% of the decision is already happened, only the 20% is pending, then one party can go to the court and say that stop this arbitration process, it is going not going in a correct manner, and give some uh, orders to the arbitrator, don't give the award till it discussed or till it discussed in the law of land or till it discussed in the court in detail. So that kind of things has to be made some provisions by the arbiter to provide that a settlement agreement reached by the parties as a result of conciliation proceedings will have to the same status and effect as an arbitral award on agreed terms on the substance of the dispute rendered by an arbitral tribunal. So it is regardless to the settlement of the agreement what we have made during the um, initial stage of arbitration process. Of course, whatever it is there, the duty of the arbiter is to satisfy the whatever the agreement made by the two parties, and it is agreed by the arbitrator. That this we have already discussed. What are the essence of arbitration? But this essence of arbitration, um, we have discussed in terms of volunteer uh, uh, and um, whatever the compulsory arbitration process. The same thing has been discussed here by taking consideration of all those points. And of course, this is main very important of essentials of arbitration agreement. It's very important. The previous one is the essentials of arbitration. Either it is a compulsory arbitration or whether it is a volunteer arbitration. So when it comes to the agreement, it must be in writing. It must have all the essential elements of a valid contract. The agreement must be refer a dispute present or the future between the parties or parties to arbitration. An arbitration agreement may be in the form of an arbitration clauses in a contract or in the form of separate agreement. Then of course the appointment of arbitrator, how exactly it is going to happen. The parties can agree on the procedure for appointing the arbitrator or the arbitrator, that we already discussed it. If they are unable to agree, each party will appoint one arbitrator, and the two appointed arbitrators will have to appoint the third arbitrator who will act as a presiding arbitrator. So many sections are there. Even if you see the arbitration laws, many more are there. Maybe I'll provide that all those sections. Of course, they are not required in detail, but still, we have around more than 29 or 30 sections are there in the arbitration process. In that, if you see the section 11.3, the arbitration, what it will say is how exactly the arbiter has to be appointed and how they have to agree it. Then conduct of arbitral proceedings. So then, when you are conducting this all arbitral proceedings, the arbiter tribunal should treat the parties equally, and each party should be given full opportunity to present his case. So that is section 18. It will say that the arbitral tribunal is not bounded by a code of civil procedure, that is, of course, Indian Evidence Act 1872. Of course, this will not be by the whatever the Indian's Evident Act or Indian Penal Code, but some of the laws are enforced into the Arbitration Act. Some of the things have taken from this Indian Evidence Act 1872, and they have taken into the Arbitration Act, what we discussed earlier. The parties to arbitration are free to agree on the procedure to be followed by the arbiter tribunal. Tribunal, in the sense, we have discussed the more than three arbiters should be there in one dispute, and they have to solve it. If the parties do not agree the procedure, the procedure will be as determined by the arbitral tribunal. Then finally, arbitral award. The decision of the arbitral tribunal is termed as the arbitral award. Arbiter can decide the dispute if both the parties are expressly authorized him to do so. That's section 28.2. 28.2. The decision of the arbiter tribunal will be by the majority, of course. Whatever they will take, that will be taken as a major decision. The arbitral award shall be in writing and signed by the members of the tribunal. Okay. For the section 29, it will say that whatever the arbiter award is there, it has to be signed, and this is a final process in the arbitration process that we already discussed. That will say the section 29. Then what will be the cost of arbitration? The cost of arbitration means reasonable cost relating to the fees and the expenses of the arbitrator and the witnesses, legal fees, expenses, administration fees of the institution supervising the arbitration, because many institutions are there. For example, arbiter, it will be there, he may be having one consultancy or he is having one company. Then whatever the company fees, or because these all arbitration process will come under the GST, and whatever the GST it will be there, that GST has to be registered for all this arbitration process. The tribunal can decide the cost and share of the each party, that they will decide that. And of course, that for one section is there 31.8, that they have to, and according to that you have to decide the cost of the arbitration. The next, the intervention of by the court, mode of arbitration, judicial authority, and some of the things we will discuss in the next class. Maybe we'll try to finish this and we'll move on to the fourth module in the next class. Thank you.